ready.
Okay, let's get started. My name is Sonya Sigler. I'm the Vice President of Business Development and General Counsel at Cataphora, and we're a software company, and we do evidence analysis for litigation and investigations. And we work with law firms and corporate legal departments on cases that are usually on the front page of the Wall Street Journal. So I can't really talk about the cases, and I'll talk about that a little bit later in the presentation. Can I just see a show of hands who are 1Ls? 2? 3? Okay. I just ask a couple more questions. Who's worked inside a law firm before? Corporation. For the people with hands up for corporation, was it in the legal department or was it as a software engineer or something else completely? Something else completely. Software engineers. Okay. I went straight through. I started out as a computer science major and philosophy major at Berkeley. I started out as computer science and music, and after I took my first computer science class and got a big old fat C-, I had to find something else to do. I knew I was going straight on to law school, so I had to pick something that would work well for it, and I ended up doing philosophy and music, and it worked really well, all the logic classes and a lot of writing, so that was really helpful as a background. I knew I wanted to be in-house after working at a law firm that had 4 attorneys in it. That was my second year of law school, and that was enough to do me in. I decided I really liked the corporate side. And if I had to do it all over again, I would have gotten a JD MBA, because I'm much, much, much more business-oriented than most lawyers. So that's one tidbit I picked up along the way. I'm going to give an overview of intellectual property issues that I've faced as a lawyer in software companies, and I've always been in-house, and I've always been at software companies. I'll give you a little bit of overview about me, and then I'll go through the slides with you. And feel free to ask questions as we go along. And also, the last slide that you'll see says, I have open intern positions. I have 2 open intern positions for the summer. They're for credit. They're not for pay. And I'm interviewing this afternoon, and Morgan Dane was setting up interview times, so you'll need to talk to Morgan for particular times. I know there are a couple people who have set times, and then I had an open time slot. So just give you that information so you can think about that while we're talking. My first job out of law school was at Sega, the video game company. How fun is that? I was really popular with all my cousins. I don't play video games. I'm terrible at them. But you face the same issues at a video game company as you do at any other kind of company like Palm or anybody that sells software. Intuit, I spent 5 years at Intuit, another software company. So all the same issues are present in those companies no matter what the software is. So I spent about 3 years at Sega, and then I went to Intuit and spent about 5 years there when we transitioned from a desktop software product on a disk to web services company. So that was a really, really interesting time to be there. It's a really good company. And then I left after I had my second kid and went to do business development and legal work for startups. So I did a lot of consulting in the last 6 years, and I've been at Cataphora for almost 4 years. And I keep getting sucked back into the legal side. I've been trying to transition to the business side for my entire legal career. But the really interesting thing is that companies need strategic lawyers who can think about the business, what's important to the business, what's important to the software product teams that you're working with. So keep that in mind as we go along. So first issues we're going to talk about are copyright issues. The actual product itself, the software, is copyrightable. It's usually on a CD, a disc, a DVD, or it's downloadable in some fashion. All of that is copyrightable. Any type of media it's on, that's all protectable. So you need to be very, very familiar with copyright issues. When I was here, I couldn't fit all the classes in and work full-time, so I ended up going to Franklin Pierce Law Center for a summer and doing copyrights, trademarks, and licensing there, and that was really helpful. So if you at all want to go into intellectual property, I suggest you take the minimum copyright, patent, trademark classes, and licensing is really extremely helpful. Staying on the copyright side, you copyright all your documentation. And usually you don't actually have to register your copyrights, but you want to if you're going to defend them. So all of your documentation, all your product itself. One thing people don't often think about is training materials. Protect those as well. Website. Now that's hard to protect. You got to do screenshots of that, and it's like if you look at the Time Machine or the Wayback Machine, I think it's called, you can see what websites look like, prior to what they are now. and any other materials that you do. We do training materials. We have separate training materials that we do for all our clients before they start using our software. A lot of things are on ASP models now, so it's a little bit tougher. So you got to be more creative with how you're actually protecting them. We have competitors who copy our advertising, copy our marketing, copy our feature names the minute they're out. So any of those, we'll protect those under trademark as well, but think about all the protection that you can do on the copyright side for all the different things in the software company. Trademark issues. At Sega, I used to get requests to review all the advertising. So that involves copyright, trademark, and the product itself. So when you look at all the ads, you have to think, am I protected? Do I have this rights to use this artwork? Do I have rights to use this music? So you kind of have to have clearance. Same thing with the trademark. Before you use the names, you want to go through a clearance procedure. When I started at Sega, there were about 300 employees and 1 lawyer, and then 2 of us just started who were still in law school at the same time. And we put in processes and procedures to actually do clearance for people, for product managers to come to us and say, we want to use this name, we want to use this character name, we want to use this product name, feature name, whatever it was. And you go through a clearance process. We usually just had a 1-page sign-off. Now it's almost all web-based. Prevent others from using it. Didn't mean you couldn't use it. It just meant you couldn't protect it, and you couldn't prevent Microsoft from using it. So that was the big thing there. Same thing with TurboTax and TaxCut and all those names with competitors. So you just need to actually work through with the product development people and the marketing people of how they're actually going to use the names. Do they just want to use it, or do they want to prevent somebody else from using it? Because if you want to prevent somebody else from using it, then you actually need to go through the registration. You actually need to send in the samples of how you're using it. We ended up doing some defensive work and getting Pocket Money and Pocket Quicken. So Microsoft couldn't use Pocket Money because they were using Pocket Windows and Pocket PC and all those. And so there's a little bit of competitive advantage there as well. So that's another thing to think about in the trademark area. Protecting the company name and the logo. You see the Cataphora. It's hard to see with the lights on, but the Cataphora logo is in the background of the picture here. Protecting our logo. It's a stained glass window with 9 colors in it. Hard to it's pretty easy to see when someone's copied it. It's hard to get away with that one. But neighborhood graph and neighbor graph. That was a feature. Neighborhood graph is a feature in one of our products. We do data analysis on evidence. So all the electronic evidence in e-discovery. We will analyze the data and we'll put it up, and we'll put a neighborhood graph up so you can see who's talking to who sent email to who, was Ken Lay, the CEO, left out of all the communications, and you can see it visually. Well, one of our competitors copied it lock, stock, and barrel and called it the neighbor graph. So we haven't been proactive at Cataphora about protecting our trademarks because the names change so often, or they just threw it up there and just called it that and never marketed the feature or anything. So we need to really do an analysis of who's going to see it, who's going to use it, how long is it going to be used, and do you want to prevent somebody else from using it. So all those things are really important when thinking about trademarks. Let's go on to patents. These are a barrier to entry to your competition. So from a business standpoint, this is it. This is the bread and butter of the intellectual property issues that face software companies. And with the business method patents, if you look at Amazon's portfolio of patents, they have an amazing business method patent, the one-click purchase. So they've done some fundamental patent work at that company. And I strongly recommend that you help your product development people do the same thing. We have a patent alias set up, so you can send anything to patents@cataphora.com at 3 in the morning. Your engineers can send you messages, and once a quarter we go over those ideas. And we say, is this covered in any of the patents we've filed so far, or do we need to put it in a new one? And we actually do provisional filings at least once a year, and then follow that up a year later with the actual filing for that patent. We're just implementing online lab notes. So all those get concatenated, and it's by time and by engineer. So whoever entered it, you can have better notes as opposed to my paper notebook, which is a pain to go find out later and a pain to comb through and figure out, really, did we talk about it 2 years ago? Shoot, we've missed the the on-sale bar. You know, have we marketed it to somebody? Did our salespeople get excited about it and talk about it and we didn't know about it? So was that included in some materials your sales guys sent around? So the online lab notes should kind of capture some of that between the engineers and the sales guys. File early and often. I can't emphasize this enough. At Intuit, we didn't have any patents filed for, I mean, there weren't even lawyers at the company for the first 10 years. So when we actually wanted to go after Microsoft for copying everything in Quicken, we couldn't because we didn't have a leg to stand on. We had copyright issues. We hadn't even registered our copyrights, so we couldn't go after them until that happened. We didn't have any patents that we could point to that they were infringing on. So it was really important from a competitive standpoint and from antitrust standpoint to be able to go after them to get them to stop copying our product. Lock, stock, and barrel, feature for feature. On-sale bar. Keep control of your marketing people and your salespeople. They like to tout every new feature you've ever mentioned or thought of or dreamed of before it's in the product. So keep their materials in check. It doesn't mean they can't go out there. It just means keep your deadlines straight. So if you've talked about a feature and you haven't patented or you haven't protected it in some way, be sure to do that in a timely manner. So my favorite, dead companies. Who owns the patents of all these dead .coms? Bankruptcy courts, banks, founders. No one. They've languished. So if the patent is at all important to you, I was, when I left Intuit, I went to a company called I Do Systems. And we were funded by the owner of Lego. And we did a 3D animation technology that even I could use. And you made little robots or you made online things that you could fight online in 2 to 3 minute battles. And you could brand them with the Nike logo on your robot. And we ended up doing a business method patent for that. And so what we did was when we decided to close that company because we couldn't make a go of it 5 years ago, the owners of the company negotiated the patent rights away. And so we own it now. Finally, 5 years later, last October, that patent issued. Now we have huge infringers, AOL, Google, Yahoo. So now we're trying to monetize that patent. And it took a lot of our own personal money, took a lot of our own personal time. We meet monthly. To actually get that patent issued. So if you're at a company, you decide to go to a startup company and it becomes defunct, make sure you know where those patent rights went, especially if you believe in the patents and their fundamental business method patents. Let's go on. Trade secrets. Now, trade secrets get short shrift, most classes. You get 1 day on it, you get 2 hours, you have a little discussion, you say, look at the Uniform Trade Secrets Act, follow that. But in reality, this is really important. This is where strife happens. Look at Microsoft. Look at the engineers they lost to, I think, Google. And they've been fighting over China for the engineers that are doing their product in those countries. So cover everything by an NDA. If you talk to a customer, you talk to anyone, get it covered by a non-disclosure agreement. Easy to find those. A lot of salespeople don't like to use them because it slows the sales cycle down. Too darn bad. Too bad. Train your salespeople. It's necessary to protect the company's assets. Confidentiality and invention assignment agreements for employees. When you start an employee or a contractor or a consultant, anybody, have them sign this agreement because you want those rights. You don't want a software engineer working on an essential part of your product, have them go on their merry way and not own it. Bad idea. When I was at Sega, we usually had developer agreements where Sega owned the product. It was work for hire. We owned it. When we went to do the Sega Channel, which meant video games were downloadable onto TV and you could play it that way, who had those rights? So we got into, I wouldn't say a pissing contest with the developers, but it really was about who owned those rights. Well, you didn't own it for that particular purpose. We're like, no, we own it for every purpose. So where did it end up? So follow the ownership and getting the confidentiality agreement, invention assignment agreement signed by anybody, contractor, developer, employee, anybody who does work on your software product. It's very important to have that in place, especially for clearance and especially if you're going to license it to anybody else. If you're doing music products, hugely important because clearance on those involves a lot of different rights. Insider trading. You wouldn't really think this falls into trade secrets, but I put it in this category because I think it does. The work that Cataphora does is, like I said, on the front page of the Wall Street Journal. We're dealing with large corporations. We're dealing with customer data. We're dealing with client data, private information, medical information. We're dealing with strategy for that particular company. Are they going to settle this class action suit? Are they going to settle this shareholder lawsuit. So we have access to all this information that's hugely important. And if you're in the legal department and you're just dealing with your own company, I was never, ever able to trade my Intuit stock. I could trade for a 3-day window in January every single year. So very important to have insider, huge typo, God, insider trading. Training for your employees. All new employees should go through that. It should be 20 minutes just to say what it is, avoid it, don't trade on other information that other public people don't have access to. Same thing with litigation strategy in law firms. You have access, you can't trade in that stock. So I put that under trade secret because it is private information. Access to customer data. We have access to all kinds of things. And one of the things we do is a hall of shame. When we finish a matter, we do a presentation for 3 hours to that corporation to say, here's all the bad stuff we found in the data you sent us. It's emails you'd never want to see on the front page of the Wall Street Journal. It's all kinds of personal information going back. Drug use, alcohol abuse, sexual harassment, affairs going on in the office. All this information, you have access to it. So treat it quietly, confidentially, privately. This is really where trade secrets have the most press. Employees leaving to go to another company. They leave to go to a competitor. I just had a sales guy leave. He's interviewing at competitors. I can't stop him because my non-compete's not valid in California, but he's in New York, so I at least get 6 months out of him. So it's enforceable in New York for at least that period of time. So that's really, you need to counsel them. Don't talk about our stuff. Don't talk about anything you've learned. You can talk about what you've learned in the industry, but not anything specific to the company you were just at. Remember the confidentiality and invention assignment agreement that you signed when you came into the company. That covers everything you learned here. So that's really important. One thing we're seeing is disaster recovery procedures. We're getting that request in contracts. What do you have in place? What happens if there's an earthquake and you guys sink into the hole that's Redwood Shores? What are your procedures? Where's your data recovery center? Do you have parallel processes somewhere else? And why is this important to trade secrets? Because it's customer information, it's customer data. Anything that's collecting information from people, where is it stored? Can anyone get access to it? Just because the server's not online doesn't mean you can't get to the information. So keep that in mind when putting those procedures together. How are you keeping that information safe in the event of a disaster? Safe and secret. This is my personal favorite about all the stuff I've done at Cataphora is espionage alerts. We have phone procedures in place. We get calls from competitors fishing for information all the time. We are not VC funded. We are completely bootstrapped, and we are completely funded by customer revenues. And we've been here for 4 years, and we have about 80 employees. So we're an anomaly in the valley. So we get VCs fishing for information, not only to invest in us, but to invest in competitors. So we have a couple procedures in place. Basically, all the phone calls get sent to me. I'm the only lawyer in there. We have another woman who worked in intelligence, and the other calls go to her. So just have procedures in place. Have website logs. Who's accessing your websites? Who's downloading all your software? If you have downloadable software online. So those kind of auditable procedures are really important. Training. We do. Every new employee, contractor, consultant that walks in the door, we do training. Expect these phone calls. Oh, I hear so-and-so reports to you. Never heard of the person. Don't answer those calls. Say, we don't use recruiters. Thank you very much. So those kinds of training procedures need to be in place. Very important to keep the structure of the company, keep the finances of the company, keep customer data secret. So all those go under the espionage umbrella. Physical plant security, data security, and website security. We are an ASP model, so people log into our software. We do the analysis. They just access the data results from it. So our physical plant security is only important if you care where the servers are located. But if you've got manufacturing facilities that you don't own and you contract to, you need to know what those are. So any kind of security procedures are really important to keep your trade secrets and your software safe. When I worked at Sega, our golden master, before it ever went to manufacturing, was out there, being counterfeited all over the world, actually. We worked closely with the Canadian Mounties to prevent counterfeit goods from coming into the country. So those golden masters, they went up on a bulletin board at the time, 15 years ago, not on the web, but a private network, and they were still out there, still copied. So it was an inside problem, still never detected it, still don't know who it was, but it happens all the time. So even if you're not doing web-based things and you're doing manufactured software, on disks or whatever. Make sure you know every step of the way how that information is protected. Data security in terms of accessing it online. Authentication and other password protection procedures need to be in place. So all these methods are used to protect your trade secrets from prying eyes, competitors, press. Let's go on to licensing. This is how I spent the bulk of my time of my career, is doing licensing agreements. When I was at Intuit, I worked with the Quicken product, and I worked with all the online banking stuff, and I worked with all the online business banks. So I negotiated with 40 banks to do all the online banking data. So if you download your Wells Fargo data into Quicken, that's the agreement I did. So those kinds of licensing deals are really important. We also aggregated a lot of content for the Quicken website. So all the Morningstar data, all of the all of the financial information. So like Susie Orman, all that kind of stuff. We licensed all that content in for our website. So licensing agreements were hugely important to the work that we did. Right now, I use PDFs. So when I send the final copy to someone, I put it in a PDF and I send it to them. Helps with version control, helps with knowing where the heck your final agreement went. I've got some agreements where we don't know where the final agreement is. We think it's this one, but putting into PDFs is really helpful. And I also have a high-speed scanner in my office, and so I scan in the signature pages in color so that people can see that that was a sign, and I slot it in. I have editable PDF, and I put it in with those. So just keeping track of your licenses is really important. It doesn't sound like it is from an intellectual property standpoint, but it is from an integrity standpoint. I also have a database of information. Now with Plone and Wikipedia and all these other tools that you have to keep track of your information and let other people in the company see it on an as-needed basis, it's a lot easier to find the information. You don't have to go to my file cabinet to find it. Or like Intuit, they didn't have anything in file cabinets. They didn't have lawyers. They didn't have any procedures. So when Microsoft went to buy Intuit to do the due diligence on the company, they had to go to every individual executive's office and look through their file cabinets. Do they keep records? Do engineers keep records? No. So it was really hard to find those documents and put them together in a way for them to even do due diligence on the company to purchase it. So it's a lot of tools out there now make it a lot easier to find and disperse the information appropriately. In terms of licensing, we talked about copyright, patent, trademark, trade secret. Lay out the obligations of the parties. What are the obligations to those intellectual property assets? Who controls them? Who can make changes to them? All those need to be laid out in the obligations and the licenses. And then term payment and then end of agreement. What happens on termination? Really important for those rights. When I talked about defunct software companies, it's also really important to put those in your licenses as a minimum to know what's happening to your intellectual property. My favorite, boilerplate. Get boilerplate that you like. Do you like arbitration? Do you like litigation? Do you like New York law to govern? Do you like California law to govern? Are you a Delaware corporation? Do you care? So get whatever is important to your company and get it set, and then don't change it. So those are some things that make it easier to continue doing repeat licenses over and over. You guys can ask questions as we go along. You're pretty quiet. A little worried. Yes?
Obviously, they're pretty expensive, so I'm wondering how do you manage deciding what you're going to patent and whether that's going to make business sense?
We decide how fundamental it is. Who else is doing it? Who else do we think is doing it? You can also do some patent searches. I don't know if you've seen the smart patent technology to be able to graphically, visually see patents in a certain area by if you're looking at software patents and information retrieval, looking at other patents in that area and if you're covered there or not, and then you can make some kind of analysis and judgment about whether to go towards that area and cover other things around what you're doing. We didn't have any money when we first started for the first year and a half, basically. And when we got paid by a customer, we dispersed it to all the employees. And we had a deal with our patent attorney, probably shouldn't say this, but too bad, that we would pay them when we got cash in the door. So we had an ongoing agreement with them to continue doing work for us, because otherwise we couldn't pay them. So we paid them, and then we keep doing retainers. So when we get a lot of money in, we just pay them a retainer, so that'll cover. And I think the most we had outstanding with them at any one time was about $15,000 on bills. So we just had a good arrangement with the patent attorney when we first started. And they knew it was a risk. that, if we bit the dust, that they wouldn't get paid. But then, they wanted the work. So we also have quarterly meetings where we decide and we look through all the ideas that came through that month or that 3-month period, and we can say, that's it's not worth adding another claim for $25 or $250 or whatever it is to add a claim in. In fact, we just added. We had some response from the patent office action, and we added like 15 more claims in. So that was like at the last hour, and we had that was about a 95-page patent, and it was really hard to get through. I think I lasted for about 26 pages before I fell asleep. And I'm not an engineer. I don't profess to be one, and I don't know IR technology other than the fact that I can talk about it and sell it. But that's what the patent was all about, and it was really tough to get through. But we made our engineers who were on those particular parts of it go through it, and so now they know what's covered in it and are helpful in the process going forward to say, oh, we covered that in the first set of 3 patents. Now we need to cover it in the next set of 5 patents. So it's just an ongoing process with them, and we do involve all the engineers. So they're invited to the meetings, and anybody who's submitted an idea to that quarterly agenda, because it just comes to patents@cataphora.com, and I get them all, the CEO gets them all, the VP of engineering gets them all, so we just aggregate them and we talk about them one by one. And so anybody who submitted for that quarter is invited to the meeting. So any other questions? Marketing and product development. When I was at Sega, I was assigned to the marketing and product development groups and the new business group and finance. Those were the groups I supported. And the other attorney at the time supported the litigation that we were in. We were in several patent infringement suits with Lemelson, the original patent troll. Paid him a boatload of money, paid him like $300 million after that infringement suit ended badly. We were headed to a jury trial, and the Japanese couldn't stomach the jury trial and letting it go. So we ended up settling on the eve of going to the jury. So it was a negotiated number. But in working with marketing and product development, it's really important to do training. At Intuit, I kept getting new product managers every year because they would hire Harvard MBAs and not give them a lot of training. So I got the same questions over and over. So for like the first 2 years, they're like, well, didn't we answer this question already? So we ended up doing proactive training. So I wrote marketing or legal aspects of marketing and legal aspects of product development, where I took them through 3 hours of training, basically 45 minutes on copyrights, 45 minutes on trademarks and the procedures, same thing for patents and trade secrets and licensing, and also advertising law. So we took them through those training programs, and they became a lot more sophisticated. They became better business people because they knew all the hot buttons. They knew that just because we signed a license didn't mean that we couldn't get out of that license, didn't mean that it wasn't a better business decision to breach that agreement when necessary. So training was really important. The other thing is processes and request and sign-off. Like I said, we're moving a lot more to web-based requests. I know Cisco does a lot of that as well. So everything that comes into that department goes through the web and gets vetted there first. So it's really important to have all those processes and procedures and the information available on the website. One of the things when I was at Intuit was between 95 and 2000 when everything was being put on the web. That helped a lot because you didn't get the same question for the same information. Where's our NDA? I need it. I'm going to see a customer. So it was always there. They could go log on and it would be right there for them. So it made it easy. Educate them. How to use a lawyer. We did a presentation in Intuit called What Can Legal Do for You? So we went through what we do. What do we do for you as a product team? We're part of your team. At Intuit, I went to all the product team meetings. I was part of the product team. So I went to all the Quicken team meetings. I went to all the QuickBooks meetings. So we were an integral part of the team. It took them a long time to get used to it because Intuit didn't have lawyers for the first 10 years. So at Cataphora, we've had a lawyer from day one. So it's made a very different cultural shift in the acceptance of lawyers as business people. Same thing strategically. What can legal do for you? Prevent you from doing bad deals, can help you vet the idea, can help you. I used to get marketing people say, why are you giving me all the comments? Why are you going through the product from beginning to end? I went through the entire Quicken Mortgage product, every single window on the web. Every little avenue you could go to, I went to. I wanted to see what the language said. I wanted to see how it was presented to the customer before I signed off on that product. I do QA with the product groups. I am one of the QA people. So when you're at a software company and you're the lawyer signing off on the product before it goes out the door, you need to look at it. Someone in the legal department needs to look at it. We had some games at Sega that had what looked like Lego bricks in them. Bad news, little problem. And I trained, when I did the training for the product development guys, I actually had them proactively bringing me screenshots of it. So I didn't have to find it on the back end. They were bringing me, is this okay? Can we do this? I think the training you gave us says we shouldn't be doing this. So it was really helpful. Advertising sign-off. So we had a name and lights program at Intuit where employees could sign a little waiver and their name would be used in the product manuals and the training manuals. So you look at some old Intuit product manuals and my name's all over because I signed waivers. So same thing when you look at the Sega stuff. You'll see the lawyers' names in there as well. So you can have programs like that are proactive and let people do what they want to do instead of 1, 2, 3, 4, Anytown, USA. You can actually use the addresses, and information from people, just get their sign-off first. So that made the advertising fun. One of the fascinating things I learned in advertising was special rules for children advertising. You can't make the product look like it's going to make them popular. You can't parody someone either. We parodied Jacques Cousteau and had a little problem with that in one of the ads. So learned a lot about advertising law, and I do a lot of advertising training to the marketing group as well. Clearance, when you're incorporating anybody else's intellectual property, whether it's software-based or code or pictures or music or video, any of those, use copyright clearance. They're good. They do a good job, so that's important. Lastly, you wouldn't think these fall under intellectual property issues, and they don't really, but it's really important for software companies. I did operations for the first 3 years at Cataphora. I was the CFO. I did everything. I did all the finance, facilities, HR, you name it, I did it. But as a lawyer in a software company, you need to be aware of revenue recognition issues. How can you recognize the revenue? Do you make the sale? Did you sign a contract? Did you actually ship the goods? So just be aware that something you'll need to be educated and ask your finance person to help educate you there. Audit rights. What do you need to do? You need to have signed contracts. You need to have your litigation tracked. So there's a few things that happen in software companies. Can you be quiet, please? Stock options. You'll have to know about those. Everybody does them in the Valley, know about them, know how to use them, know what to do with them. Employment procedures, entry and exit procedures. Make sure you have training and disclosure when they come in. Make sure you interview them when they go out. And sign that they've given all their equipment back and they haven't taken any trade secrets with them. And they're still going to abide by the trade secret agreement that they signed. Facilities, leases and equipment. A lot of computer equipment gets leased these days. So make sure you know where that is when you have to give it back, all that kind of thing. So that's kind of important from an integrity standpoint where you're trying to develop software and you want continuity. So litigation. IP litigation is hot. It's the way to protect the company, way to keep it going. I mean, my favorite one recently is the RIM BlackBerry. Everyone's waiting for their BlackBerry to turn off. Trade secret theft is the other big one that happens in litigation from an IP standpoint. So infringement and validity from the patent standpoint, and then trade secret theft are the three main areas where you see infringement or IP in litigation. Just a few observations, and then I'll answer questions. IP is incredibly important to a company's success. Whether you can prevent somebody else from stealing your stuff or whether you can beat them to the market and you've got a barrier to entry for other competitors, hugely important. Protection of it is really important. So put procedures in place to protect things quickly and consistently. IP issues permeate an in-house counsel's job. So I've always been in-house, and you can't avoid it. It's everywhere. So you think the HR person doesn't need to know about IP issues? Wrong. They do it in the training. You think facilities people don't need to know it? Wrong. They need to know, well, that server room has all our servers that we host data on for all our customers. So IP issues really permeate every aspect of an in-house job, no matter what you're doing, whether it's only IP related or if it encompasses operations or anything else. Business judgment is paramount. You don't have time to research issues and go figure it out. You need to trust your judgment, and if you don't know, ask. If you don't know, go ask. Really, really important. And business people don't care if you say, I don't know, I'll go find out. They are perfectly acceptable with that answer. But it is important not to bullshit and not to make up stuff as you go along, because you won't have time to think or research. You may have 5 minutes to go find an answer. You may have 5 minutes to call outside counsel and say, what do I need to do here? So business judgment is really important. So when I said earlier I should have gotten the JD MBA, there it is. Strategic thinking is very essential. When I talked about being a part of the product team, being a part of the business team, that's really important if you're in-house, and very important when you're protecting IP. And the Morningstar example I'm going to use is QuickBooks was over here trying to get the data in. The web team was trying to get the data in, licensed for the website. The Quicken team was trying to get it in for the finance aspect of the product. Nobody was talking to each other. So they came to us to do licenses, and we're talking about it in our staff meeting, and we're like, these guys should really talk to each other. We should do one license. So bridge the gap between disparate product groups who are really siloed and only talk to themselves and don't talk to other product groups in the company, because different companies have different cultures. So that's one way. Strategic thinking is essential to your product teams and to their success. So those are important. Contact information. And like I said, I have 2 open intern positions for the summer, and actually it's ongoing. So if you don't want the summer and you want the fall or the spring, email me. Questions? Yes.
So obviously, you as an in-house person, you're dealing with so many different areas of law all the time. How do you sort of decide when to use outside counsel and when to do things yourself?
I'm an intellectual property lawyer, and I do licensing. I don't do HR. I don't do stock options. I don't do corporate stuff. So I hired outside counsels in the areas that I know I don't do, and I never want to know more about HR than I know now. Just wait till you get to your first sexual harassment investigation, and then you'll agree. So what I did was I went out and I hired counsel. I hired Fenwick & West. I hired Morrison & Forrester. I hired Blakely and a couple other patent firms to do work for me. And so I know when an HR issue comes in the door, my first call is to Dan. I'm not going to try and answer myself, because HR has nothing to do with logic. And that's what gets you in trouble. So I just make a call to Dan, and people know that. So that's what I've done in order to use outside counsel effectively for what I know.
And also all the corporate issues with stock and all that.
Absolutely. I have the best stock paralegal. I mean, administrating stock options is a nightmare. I mean, it's just like a paper trail that never ends. So just pick people that you trust and work with. And if you can't work with the outside counsel, or it's not working out, or you don't have a good relationship with them, change counsel. I've done that already. So I'm not. I mean, it's a two-way street. They have to be comfortable with you. I have one of them calls me up maybe once or twice a year and takes me to lunch and says, I'm not going to charge you for it. I love that. Because it gets to know what's going on in your company, hot issues, any employment things burbling, to the top. And so he knows what's going on. And I let him know every issue I ever think is, in there, so that he's prepared when I make the call, because I don't want him to say, oh, it's going to take me a week to get back to you. That doesn't work for me. So I just have a pretty good relationship with the counsel that I've hired. And it is a work in progress. So, you had a question?
Yeah, I was wondering how often do you actually get letters, say, giving you notice that you're infringing or threatening to sue you over patent infringement? And how do you tell when they have a legitimate leg to stand on in an evening jury, or you just throw it out?
Oh, yeah, we've had all of that. At Cataphora, I haven't had that at all, because we're a stealth company. We don't do a lot of advertising. Competitors are afraid of us because we're not VC funded. So I haven't had that at all. But when I was at Sega, we got them regularly. We got people who wanted to license in peripheral technology, for headsets or for the gun or the joystick or whatever. All the time, got things there. But it was mostly proactive. They wanted us to license their technology and sell it as a peripheral. We did get some, like the Lemelson. We get letters from them all the time, and you stick them in the shredder. But there are some where you actually had to do an infringement analysis, and you had to go through and do the claim analysis, and you had to spend a lot of money. And then the strategic part of it comes in and says, do you want to spend $300,000 vetting this claim or these 5 patents? Or, when IBM knocked on our door and said these 342 patents are, all infringed by your stuff, that was a different answer. So you had to have patents in your portfolio to use as a shield in that case. And we didn't have a lot, so it was hard for us to negotiate, other than the fact that we were an 800-pound gorilla in that video game market. So it just depends on what it is and what kind of company you're at. I mean, at Cataphora, if I got an infringement letter today, I'd be hard-pressed to do a claims analysis because we've got some fundamental patents in our area. So I'd be suing them for infringement, would be my first reaction. So it just depends on what the company is, what the product is, and where you are in the development cycle. I mean, if you're a mature company like Sega was at the time, you'd have a lot more resources too. I mean, our legal budget ended up being about $1 million a month there. So, you know, and now I have like 5,000. So it just depends on where you are and what your resources are. Michael?
in all the startups I worked in, it was really hard to get engineering time to do anything other than work on the primary product of the company. And it sounds
Absolutely.
like, you know, you managed to get at least some tools out to help you do your job. How did you find the resources to do that?
It's a work in progress, and I have a UI engineer who lives out of state, so he's not always in sight for other people to use him. So I've used him to do some HTML work to put the website up because I don't do HTML. So that was really helpful to get that started. And I also poached somebody from the QA group to help me, like changes to the employee handbook. You know, it hasn't been changed for 2 years. And so I had taken all these notes, and I just have been traveling so much. I travel about 2/3 of the time to do the business development side of my job. So I just have, I mean, we've had 20 people at the company until about 18 months ago, and now we're at 80. So I have a little more flexibility right now than I did before. And with interns, I'll be able to do a lot more. Never a dull moment. I mean, you asked about mile wide, inch deep. That's what it is. I mean, as general counsel, that's what it is. If you want to specialize in something, then be litigation counsel or be HR counsel or be, you know, operations counsel. But as general counsel, you get a little bit of everything. Yes, in the back.
As a follow-on to the question, how much do you tend to direct your engineers or keep track of what other people are sending parking letters about and direct your engineers to be away from that, or even looking at the landscape and figure out where the landmines are or do you just kind of more run
on the track we're on now, where we don't have $10 million sitting in the bank to be proactive about anything, we are completely reactive. So my engineers have their heads down coding, doing customer implementations, customized software for those. So they are not out there. Occasionally they'll look at, you know, they have their little things that they keep looking at and their RSS feeds and all that. So occasionally I'll get an article about something. Well, they'll send me, then I got to go check it out. Or they'll say, hey, Stratify's new whatever has, you know, been published, and you know, make a few snide comments that aren't printable about it. But I get a little bit of that from engineers. But for the most part, I keep them out of all things legal. I try not to involve them in finance things or as the contract sign or anything like that, because I just want them working on code. And we just hired a VP of engineering, so they'll even be more autonomous. So my interaction with them will be even less. And I'm not doing client services on a day-to-day basis either anymore, so I don't have to do that. And work-family balance doesn't exist. It doesn't.
For a lot of people, that it's very hard to go from law school to in-house. The only way to go is to go to a firm.
Can you go sit over here?
Can you explain how you managed to do that?
Sure. I went on an unusual path. People don't usually hire you in-house right out of law school. I started when I was in school. I am my last semester, so I started in January and worked my last semester. And the guy who hired us was an alum here, and he couldn't decide between the two of us, so he hired us both to share the job and work part-time, which ended up working out really well because the growth pattern of that company really needed 2 more lawyers there to put some infrastructure into place to be able to grow. And so that just ended up working out really well. And then I took the bar and then went back full-time after that. But I worked at Sun Microsystems between college and law school, and each holiday, you know, every time I had off, because my mom was there, and so I worked there, and then worked for a couple other groups in channel marketing, and with Peter Choi and a couple other lawyers there, and you know, tried to get an in-house job there, and they basically told me go malpractice on somebody else for 3 years and then come back and talk to us. So most, which is what first, second, third year lawyers do. So that's why you have a mentor. But that is true. You need the experience, and you don't have the perspective. And so what I did, and I wish I had done better, was use my outside counsel more wisely. Show me why this agreement is this way. Show me your favorite licensing agreement and why it is. Tell me, I had receivables financing for, $500 million. I didn't know beans about receivables financing, but I should have used my outside counsel in Chicago better to say, and I'm still in touch with her today, what do I need to know? What are the top 3 things I need to know? I did that with my M&A counsel. So every time we acquired another company, I'm like, oh, tell me everything I need to know. Where's my due diligence checklist? How can we get through this better each time? And we ended up doing, at Intuit, we ended up doing best practices with Cisco's legal department to say, okay, you guys are acquiring 1 to 2 companies a month. We're acquiring 1 to 2. How are we still standing? Because when you do an M&A, it's your life for like 6 months. And then you want to, take a 3-month vacation and come back. But if you're doing 1 a month, you don't get that let up. So it really is use your outside counsel wisely and pick their brain for everything. Because then you'll be smarter for the next time you have that same transaction happen. Okay, you have to stop. Did you have any questions? Yes.
You started Cataphora without any outside funding.
Uh-huh.
Does that affect the structure of your business?
Yeah, we own it all.
A corporation or a partnership?
It's
Limited liability company?
it's a Delaware C Corp, and we own it all. So we have no outside investors, we have no friends and family, we have no angels, we have us. And so it was sweat equity, basically. So we own all the company. And it's a very different structure than you will get more stock options coming to us because we have more stock to give, because the VCs don't own 80% of our company, we own it. So that's very different. And it's very hard to do, and when you have no income for 1.5 years, you have to have an alternate income source. Or not, and rack up a lot of debt. So, people did a lot of different things to survive for that period of time before we kept getting, a reasonable cash flow in the door.
Did you do small business loans?
Nope, couldn't get them because they want money in the bank to give you a loan. Banks want money in the bank to give you a loan. They're really risk averse. So we weren't able to get loans. So we ended up doing credit cards. And so it was my personal Social Security number loaned to Amex for all of our corporate credit cards. So there are some things I wouldn't advise doing that we did. But you do what you need to do to survive because you think it's a really great idea. So any other questions? Yes?
Is it typical to have in-house counsel on the product development teams, so close to the product? Or
No.
is that unusual?
When I was at Sega, I was assigned to the product development team. Do we have to get out of the room at 1? 5 minutes ago? I went around and I would talk to them. I didn't go to their team meetings when I was at Sega, but I did go to the new, anytime we were considering licensing something in or the new product ideas, I would go to those meetings because those would be the licenses we would have to negotiate. But at Intuit, we did that because it worked well with the product team. And I do it now because I've been there since almost day 1. So it's cultural and it does require change. It required a lot of change at Intuit. So thank you. Like I said, if you have any questions. Thanks.